morning, I'm Leng, Let's start again. Good morning, I'm Leng, a Senior Counsel of the Supreme Court of Singapore. I practice as counsel and arbitrator at Duxton Hill Chambers. Today I'm going to talk to you about dispute resolution options along the Belt and Road.
Sorry for that.
Your belly is showing.
Yeah, okay.
I think can. If you don't move around too much. Okay, that's good.
Okay.
Start
Second, I think we don't need to say good morning, just say hi rather, because you don't know where to go.
Sure.
Hang on. Okay, ready? One. Yeah. Okay. 1, 2, and go.
Hello, I'm Leng, a Senior Counsel of the Supreme Court of Singapore. I practice as a counsel and arbitrator. Let's start again. Hello, I'm Leng, a Senior Counsel of the Supreme Court of Singapore. I practice as a counsel and an arbitrator with Duxton Hill Chambers. Today I'm going to speak to you about dispute resolution options along the Belt and Road. The Belt and Road has created tremendous opportunities for investors and their host countries. It is fine to get excited about the inflow of funds and growth potential. But what happens when things go wrong? Given the scale and complexity of projects along the Belt and Road, disputes are inevitable. The disruption to trade, supply chain, and infrastructure projects caused by COVID-19 has put even more severe strain on deals and transactions. What I would like to do today is a quick survey of the options that are available when disputes arise. I think I've just made an error, so I may have to start again. Sorry.
Okay, would it be easy? Let's break it up into parts then. Is it
Do you actually pause the video?
We won't pause it, but we'll just then you can start.
Okay, I'll just run and then let's see where you can
Okay.
do it. Okay, I'll start again. Hello, I'm Leng, a Senior Counsel of the Supreme Court of Singapore. I practice as counsel and arbitrator with Duxton Hill Chambers. Today, I'm going to talk to you about dispute resolution options along the Belt and Road. The Belt and Road has created tremendous opportunities for investors and their host countries. It is fine to get excited about the inflow of funds and growth potential. But what happens when things go wrong? Given the scale and complexity of Belt and Road projects, disputes are inevitable. The disruption to trade, supply chain, and infrastructure projects caused by COVID-19 has put severe strain on deals and transactions. This is a quick survey of the kind of disputes that can arise and the options available to resolve them. In particular, what can investors do if things go wrong with their investments in the host country? When problems arise in the host country, it is natural for an investor to look at the contract it has with its counterparties in the host country to see if there is any contractual recourse or solution. If properly drafted, a contract will also provide for the options by which those disputes can be resolved. However, things can happen which do not fall within the ambit of the contract. Changes that are happening in the host country might give problems to the investors that cannot be resolved by reference to the contract. For example, if there is an introduction of an exorbitant tax rate or a change in the environmental policy of the state regarding, say, nuclear energy or fossil fuels, or the introduction of a ban on tobacco advertisements, This may have an adverse impact on the bottom line. The investor may also occasionally face preferential treatment given by the host country to a local competitor. In more extreme cases, there might be an outright seizure of the investor's assets. BITs, which are bilateral investment treaties, and FTAs, which are free trade agreements, typically seek to protect an investor from such contingencies. Some of these treaty stipulated protections are also recognized under customary international law. Typically, a BIT or FTA will also have ISDS provisions. ISDS is an acronym for Investor-State Dispute Settlement. If negotiations and diplomacy fail, then an investor or the state might just have to look at the ISDS provision. The most common form of investor-state dispute resolution mechanisms are arbitration and court litigation. Let's start with arbitration. There are two types of arbitration that may be of relevance. The first is exit arbitration. Exit stands for the investor-state dispute resolution. Shall I just run by this again in the second part? Let's start with arbitration. There are two types of arbitration. The first is exit arbitration. exit stands for the International Center for Settlement of Investment Disputes. It is a self-contained arbitration regime under the Exit Convention, created specifically to deal with investor-state disputes. Exit is part of the World Bank and is headquartered in Washington, D.C. The other type of arbitration is commercial arbitration. Essentially, it covers all kinds of arbitrations that are not exit arbitrations. Investor-state disputes can be determined by commercial arbitration, if so provided in the BIT or FTA. Many popular arbitration institutions are used to administer commercial arbitrations. Among the most prominent ones are the ICC, International Chamber of Commerce Court of Arbitration, and the SIAC, Singapore International Arbitration Center. Two key factors will affect an investor's choice of arbitration forum: the reputation of the arbitration institution and the reputation of the seat of arbitration.
Sorry, can you say that one more time?
Two key factors will affect an investor's choice of arbitration forum: the reputation of the arbitration institution and the reputation of the seat of arbitration. The seat of arbitration is the jurisdiction where the arbitration is held. The 2021 Queen Mary University White and Case Survey reports that Singapore is now ranked the most popular seat of arbitration in the world, jointly with London. What about court litigation? Well, an investor typically does not like to have its claims against the host country being determined by the national courts of the host country. Likewise, the host country would not like to have investment claims brought against it by the national courts of another country. In recent times, there has been a proliferation of international commercial courts, which are established to determine disputes with an international character. The Singapore International Commercial Court, SICC, is one of the most high-profile and innovative ones. The SICC has all the benefits of being a court within the Singapore Supreme Court system. At the same time, it borrows popular characteristics from arbitration. The judges of the SICC are drawn from a pool of Singapore judges and international judges from both common law and civil law countries, thereby ensuring a truly global outlook on disputes of an international character. The SICC has flexibility in procedure, and foreign counsel may make submissions directly on foreign law to the court. Foreign counsel has the ability to represent their clients and address the SICC in offshore cases that have no substantial connection with Singapore. I would like to mention mediation. Commercial mediation is rarely used in investor-state disputes, but mediation is gaining popularity among users because it is a more efficient, quicker, and cheaper way to resolve commercial disputes if parties are willing to settle.
Can you say that again? If parties are willing to settle?
Mediation is gaining popularity as a means of resolving commercial disputes because it is cheaper and quicker if parties are willing to settle. The United Nations Convention on International Settlement Agreements resulting from mediation, popularly known as the Singapore Mediation Convention, received overwhelming support when 46 countries turned out to sign it at its signing ceremony in Singapore. The Singapore Convention came into force on 12th of September 2020. The Convention obliges contracting states to enforce settlement agreements arising from mediation. Enforcement may be refused only on specified situations. Enforcement may be refused only in specified situations. For example, if the settlement agreement is null and void. I conclude with this reminder. Cross-border investments can bring high returns. At the same time, they carry significant risk. It is therefore critical for parties to set aside time to consider what dispute resolution mechanisms might work best for them when they are drafting their contracts. The terms of a contract are only as good as one's ability to enforce those terms. Thank you. So how will you deal with all those mistakes along the way?
Oh, we'll cut it out.
And so we have two cameras.